Yes, thank you.
You're welcome. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5195, Open Technology Fund et al., Appellants versus Michael Pack in his official capacity as Chief Executive Officer and Director of the U.S. Agency for Global Media. Mr. Beck for the appellants, Mr. Sinzak for the appellee.
Mr. Beck and Mr. Sinzak, nice to see you. Sorry we can't see you in person, but this is as good as it gets for us. Mr. Beck, you have 15 minutes.
Thank you and good morning, and may it please the court. I'm Greg Beck on behalf of the plaintiffs, Open Technology Fund, and its directors. The question in this case is whether the U.S. Agency for Global Media, a federal agency, has the authority to remove and replace the officers and directors of Open Technology Fund, a private nonprofit corporation. The default rule in this country is that the federal government has no power to control the boards of private corporations. And that background principle is especially strong in this context, where we're talking about a nonprofit corporation that's devoted to expressive activity. So for the government to prevail in this case, it has to show something special about OTF that separates it from a typical nonprofit. And the government points to two things: the International Broadcasting Act and OTF's own bylaws. It's wrong on both counts.
Could I interrupt for 1 second?
Yes,
even if it were right about the bylaws, isn't the point of our opinion in California Independent System Operator that there has to be a statute in order for which would authorize the government to take over a board?
Yeah, there has to be. Oh, yes, I think that's a good point. I mean, even assuming that bylaws sort of authorize a federal official to, take this kind of action, a separate question is then, can the federal official actually do that? And I think it's problematic that a private corporation could sort of draft a federal
It's not just problematic if the statute doesn't authorize somebody, a federal government official, to remove and replace a board. Doesn't matter what the bylaws say. Even if the bylaws say we'd like the Secretary of Defense to be our chair to decide who's on our board. There's no statute that authorizes the Secretary of Defense to do that.
I think that's right, Your Honor. And the statute sets out a limited set of powers that the CEO has, and that's not among them. Also, I think 6209D, it specifies by specifying what kinds of officers and directors the CEO can appoint. It also, by implication, rules out appointing any other officers and directors for different kinds of organizations. So I think that's correct.
Relatedly, Mr. Beck, if do we have to reach the question of the limitations on Mr. Peck's authority if we think that his potential residual authority, if we think that the authority he's pointed to, which is authority over organizations that are authorized under the statute, if that's what he's relying on, and that is also the identical terms in the bylaws that he's relying on. And so I guess what I'm asking is, it seems, and I think your briefing supports this as well, that when the district judge said the statute doesn't authorize this, but the bylaws do, that seems internally inconsistent to me.
Yeah, because the bylaws, they simply reference the statute, and normally if you read a contract that just incorporates a statute, the only reasonable way to read that is incorporating the statute as it's actually written, not some alternative version of the statute that creates additional powers that aren't in the statute. So,
well, what if the statute's ambiguous as to whether PAC has this authority, and he and Open Technology Fund both read that ambiguity, that he does have this authority?
So I think, first of all, under you have to look, I think, at DC nonprofit corporate law and DC contract law, especially, and the rule in DC, which is the default contract interpretation rule everywhere, is that the plain text controls if it's not ambiguous. Now, if there is an ambiguity, I think the next step is to look at what the default assumption.
But I was saying if there's an ambiguity in the statute and therefore in the statutory term that the bylaws incorporate, and if both the relevant parties say, oh, we think this puts us on a par with Radio Free Asia.
Yeah. Well, I mean, just first off, I mean, there's certainly no evidence that that's what both parties thought. In fact, the only evidence of actual intent of someone involved in the drafting of the bylaws was Libby Liu's declaration below, and she was emphatic that she did not believe that PAC would be given this authority. And so, and there's no contrary indication that the agency felt differently. In fact, if you look at the language of the bylaws, I think it backs that up. It says all the provisions regarding appointment of officers and directors say that they may be appointed as may be authorized under the act. And I don't know why they would have written as may be authorized if they definitely felt that it would be authorized in that case. Similarly, section 9 of the bylaws, this is the part that talks about the CEO, actually discusses the CEO appointing directors and whether there's a conflict of interest in that case. And it says that there will be no conflict of interest from a CEO appointment, provided that such appointment is authorized under the act. That's pretty clear that there's an understanding that it may not authorize that. And I think
isn't that really the question of whether the authorized under the act language at 6209 would include this entity that we're dealing with in this case? Is that not really the question, or am I misreading things?
I think that's right. The question is OTF authorized under the act? I think that gets right to the core of the question in this case. And
if it's not, then as was suggested earlier, the bylaws couldn't create a power in the government official that isn't there by statute. Would that not be? Don't we have to come back to the statute rather than ending with the bylaws, right?
I think that's how I would prefer to look at it as well. That the statute controls what the CEO's authorities are, and the bylaws can't extend power beyond the limit that the statute creates. And OTF is not authorized under the act for the simple reason that it's not like the quasi-government broadcasting entities that are governed by the act. It's not mentioned anywhere in the act. It's not created by the act. It's not mentioned in any legislation that Congress has ever passed.
In your own pleadings in the case, you refer to the entity as having been incubated within Radio Free Asia, right?
That's correct. It was well.
No, it's not incubated. It was conceived and hatched within Radio Free Asia as well, wasn't it?
I would put it a little differently. I would say that the idea for Open Technology Fund began at Radio Free Asia, but the legal entity that's a corporation under DC law was created in 2019 by filing the Articles of Incorporation. The fact that the idea came from Radio Free Asia, I don't think controls its nature.
The implication for the DC Superior Court, for us of the DC Superior Court litigation, is there going to be any, should we be abstaining, or could that litigation resolve this litigation?
Well, I think, Your Honor, that the primary questions in this case are the ones we've been talking about, which are questions of federal statutory interpretation, which I think is well within this court's domain. Now, what the DC courts have expertise in is the nonprofit law. And what the Attorney General said in its filing is that there's the background presumption and the normal assumption is that the directors control their own leadership. And I think as long as this case isn't going to turn on the presumptions of DC nonprofit law, I don't think there's a need in that case.
What do you think the words "are otherwise authorized under this act" refer to if they don't refer to an entity like the one we have here?
Well, I think it reflects sort of the unique nature of the International Broadcasting Act, which is kind of an accumulation over time of different entities that were founded over the past 80 years. For
Is it
example,
an empty set if we don't include in it the entity before us today?
What does it include? Right now, I think it includes nothing, but I would point out that that problem is not one that's unique to our side, because at the time that the statute was passed in 2016, OTF did not exist as an organization. So
right. that would be consistent with it either being included or not included in the term "or otherwise authorized."
Right. It does. What it means is that under both interpretations, there's a problem in that this phrase doesn't seem to include any entities at the moment.
But Radio Free Asia didn't just think of this idea, as you put it. It actually, I think your written document is better, that it incubated this entity in Radio Free Asia. And unless it was acting as an unauthorized renegade government agency, wouldn't you have to say it's authorized under this act?
No, because I think authorized has a particular term of art meaning in that it means that
Congress, I know it does, because I was in court governance for some years, and we had to talk to the authorized and the appropriators and beg them for money all the time. But,
exactly.
I know it is a term of art in that context, but this is not the same context, is it?
I thought in your briefing you referred, Mr. Beck, to Radio Free Afghanistan as having been authorized or established. So right, that's established under the act, but not authorized?
No, I think Radio Free Afghanistan is authorized under that. That's one example of an organization that's not listed, but that could be included in that residual clause. I think a possible problem is that it's a subdivision of Radio Free Europe, so I didn't want to rely too heavily on that. But I do think that it is clearly authorized in the act, and that would, under the plain language, give the CEO authority over it. And back in 2004, when Congress created the Middle East Broadcasting Corporation, it did that in appropriations legislation, and it didn't mention it in the International Broadcasting Act. That happens to predate the statutory provision that we're talking about today. But if Congress did something like that next year, created a new broadcasting entity, which happens all the time, this is a constantly changing assemblage of different groups, then it wouldn't need to amend the International Broadcasting Act. It could just create new entities. As long as they're authorized under the act in the appropriations language, then they would be included in this clause. So that, I think it makes sense as a sort of an accumulation statute of different organizations. And also, we point out in the briefs that the statute gives the CEO authority to incorporate new entities, and we think it's reasonable to think of that as Congress delegating to the CEO the authority to create new entities under the act. And in that case, those new entities, I think, would be reasonable to think that they're included in that phrase. I'd like to reserve the rest of my time for rebuttal unless there's more questions.
Are there further questions from the bench? Okay, you may reserve your time, Mr. Sinzak.
Thank you, Your Honor, and may it please the court. Jerry Sinzak on behalf of the government. As has been discussed, this case focuses on primarily whether OTF is an organization authorized under the act. And so I just want to be clear as to what we think authorized under the act means.
Could I just interrupt you for 1 second? Do you agree that if it's not authorized under the act, that the bylaw argument is not relevant?
So, Your Honor, I mean, I don't take that as an argument that plaintiffs have made here. And so,
I'm asking you a question now. The district court said it was not okay under the statute, but is okay under the bylaws. What's your position? I don't understand how that's possible. And I'd like to know what your answer is on that.
I mean, Your Honor, at least as far as the plaintiffs haven't contested that. I know Your Honor. I know, Your Honor, and I don't want to focus on this. I understand your point from the case that you cited.
That is the title of one of the sections of their brief, that there has to be statutory authorization. So what is the answer to that question?
Your Honor, I'm not sure what the answer to that question is. Because it hasn't been briefed. I would say
it was briefed. It was in the amicus brief. So you knew this was coming. So the government must have an answer to this question.
I don't have an answer to this question. I guess I would say, at a minimum, it does shed light on the meaning of what OTF and what the government understood and USAGM understood the statute to mean. So at a minimum, I would say that. But
you're not. Are you willing?
I'm not willing. I mean, I can't at this point concede because that argument hasn't been presented by the plaintiffs. But I would like to focus on
the statute, and you just had a not-for-profit corporation that put in its bylaws or in its charter, the Secretary of State or some other official can replace our board. That wouldn't work, would it?
Your Honor, I agree that would likely not work. So I do want to focus on the statute.
In order for anything to work, don't you?
Yes, under this court's law, it has to be. So I do want to focus on the statute, and I want to explain what authorized under means. It means authorized to function as a U.S. international broadcasting entity with funds provided by USAGM, and that requires that you agree to be subject to the IBA and its dictates, which are, which include promoting U.S. foreign policy and acting consistent with U.S. foreign policy, and and being subject to USAGM's close oversight. And if we just take a step back and look at, the practical reality of how this entity was formed, it wasn't a nonprofit formed out of nowhere. It was incubated by Radio Free Asia. It was spun off from Radio Free Asia at the request of USAGM. It went to Congress and said, Congress, please provide the funds to spin this organization off, because we think we can oversee it better and streamline its operations better. Congress agreed to do that. It was incorporated by Radio Free Asia's president. It was its board, its initial board, and at all times has been USAGM's governing committee. So if there's any organization that's authorized under the act, it's this one. And I would also just like to point out the history of U.S. international broadcasting. There are very few entities that have been in this realm. But as times have changed, as audiences have changed, as technologies have changed, some of these organization structures have changed. Radio Free Europe and Radio Free Liberty was merged. The Middle East Broadcasting Networks, which isn't otherwise established in the statute, it was spun off of Radio Free or Voice of America after 9/11. Obviously, the IBA contemplates the merger of Radio Free Asia and Radio Free Europe, et cetera. So Congress, when it's creating this catch-all provision, is contemplating that things will change in the future, and there will be additional entities potentially spun off or consolidated. And that's exactly what happened here. OTF was spun off, and its whole purpose, its whole reason for being, is to provide, to further the policies of USAGM and U.S. foreign policy. And this will not, open the Pandora's box, I think, that plaintiffs are presenting here, to say that, authorized under means an organization that was spun off of another radio broadcasting entity that was done so at the request of USAGM with funds provided by Congress to do the work that it was doing, the same exact work it was doing under Radio Free Asia. There's no suggestion it's doing anything different.
Mr. Sinzak, I must confess I've been distracted by your earlier assertion that Open Technology Fund didn't make the argument that the bylaws incorporation of the act can't give the agency more authority than the act itself gives. In other words, if the act doesn't confer this authority, the bylaws can't either. And I had thought that was squarely in their briefing, and in fact it is. So
well yes, I mean, I guess their argument is it goes no further. Our argument is that that it should be interpreted to as at least the founders understanding it. But even if Your Honor accepts
that's
the
argument, very different argument. So so the Open Technology Fund argues that it doesn't matter whether, sorry, I'm going to flip the negatives, but that you're making an argument based on the bylaws in the alternative, even if you lose the statutory argument. And they're saying it just isn't an alternative argument if you lose the statutory argument. And your answer to that is that you're not addressing that?
No, I guess, I mean, the answer that we gave was that, you know, as, you know, bylaws ordinarily are interpreted according to contract principles, and that if everything about the bylaws exemplifies the understanding that the initial not incorporators, but the initial board understood it would cover OTF. That's our argument. The separate argument that it couldn't have done that unless it had authority under the statute is not one that the plaintiffs themselves have made. All they're saying is—
I understood that when Judge Sentelle asked you the same question, you said you agreed it was likely that—
yes, Your Honor, and I don't want to fight about that particular premise, because I do agree that the case law is on their side about that, although they didn't make that argument specifically. But I think we should focus on, you know, focusing on the statute itself. You know, OTF is clearly an organization that Congress had in mind that was authorized under this statute.
And the difficulty then is, how do you distinguish if receiving money and being part of what advances the overall objectives of USA Global Media, how do you distinguish the daycare or other recipients of?
Well, as we said, first of all, there are very few other recipients. And what the key is that they have agreed to carry out U.S. international broadcasting activities. And, you know, the daycare isn't doing that. The daycare is providing, you know, an ancillary service to, you know, the employees of the people. And here—
it depends where you draw the line, because the fund says it's an ancillary service, you know, supporting the technology capabilities and the you know, privacy tech capabilities, but not actually itself broadcasting content.
Well, I think, you know, the idea that this isn't a central tenet of U.S. international broadcasting is belied by both the statute itself, which says technology is an important and central part of international broadcasting, and also the report that USAGM submitted to Congress in asking that this entity be spun off and separately funded, made clear that, you know, internet dissemination is crucial to U.S. international broadcasting going forward, that, you know, this is an important technology that needs to be shared with the other entities, and so on and so forth. And again, if you look at just their bylaws and certainly the grant agreement, it makes clear that their reason for being, their purpose, is to further the strategy and policies of USAGM. And this isn't, again, this isn't a Pandora's box where there are going to be a number of entities that are, you know, tricked into thinking that they're now U.S. international broadcasters. I mean, you have to agree to, you know, form your policies around, or your activities around U.S. foreign policy, and to further the views of U.S. Policies. And so that, you know, there aren't entities that are willing to do that. That's why there have been no private entities. There are no other entities that plaintiffs can identify. And
I guess I am a little worried that it could be a Pandora's box. I mean, there are a lot of private entities that have their own First Amendment rights and autonomy that work very closely with the government. And I'm thinking of, you know, social services organizations that are, when they get a lot of money, and they absolutely are carrying out governmental objectives in the way they administer that money, but they also are independent as a governance matter, and I'd be surprised if the assistance that they receive made them vulnerable to. And I understand that that's some steps away, but so just as a formal matter, not looking at sort of the understandings, but as a formal matter, your strongest argument for this authority is the statutory reference to authorized.
Yes, that they are an organization authorized under the Act.
Is your position then that if there is a nonprofit that's established totally on its own, and they accept grants which require them under the statute to permit supervision, following the government's policies, et cetera, that any grantee who agrees to those kind of conditions, the board can be set by Mr. Pack? Is that the position?
I mean, if they agree to be subject to USAGM's oversight and the IBA's principles and standards, yes. Yeah. But there have only been 4 entities that have ever done
but so then we're going back to the question we asked before. If a corporation agrees to grant conditions, Does that give the cabinet secretary the authority to replace their board?
If there's a statute that says, and we have to understand, what does that mean to say you can control the board of any entity authorized under the statute? And
What about under this statute and this program, you now have the Office of Internet Freedom that is within the USA Global Media, and it's giving grants. The technology companies that are acting pursuant to those grants, are they authorized within the meaning of the statute as you read it?
Well, I don't know that has started happening, but if an organization accepts a grant and they agree to all these conditions, that they are going to be a U.S. international broadcaster, that they're going to act consistent with U.S. foreign policy, that they will be funded by USAGM, then yes, they would be authorized under the statute.
That would be automatic without having a separate provision in the grant agreement to that effect. That would be automatic just under the statute.
It would be automatic under the statute. There wouldn't need to be a separate provision.
So if I'm a tech company that receives money to support the broadcast mission, and I have some program that's to support the broadcast mission by doing tech support to journalists and repressive regimes, that alone is enough in your view? Well,
I just want to be clear. There haven't been such entities until
presumably
now.
There will be, because you've resurrected the Office of Internet Freedom.
Well,
and I don't know if it does subsidiary grant making. Maybe it doesn't. But if it did, that would seem to propose exactly that.
Well, Your Honor, just again, if there haven't been, the reason why there aren't private tech companies willing to do this is because you have to agree to be effectively, an arm of the U.S. government, that you have to promote U.S. government. Yes, you have independence, some measure of independence in your operations, but you're agreeing to act consistent with U.S. foreign policy. You're agreeing to conform your operations to USAGM policy and strategy and its understanding of U.S. foreign policy.
But you're saying, though, that this statute authorizes Mr. Pack to set up new arms of the government, new nonprofits, in which he appoints the board. Is that your?
Well, the statute
Pack alone, as the CEO, has the authority to make the grants and then demand that they be the chair, that he appoint the board. Is that the government's position?
Well, that's Congress's position in terms of.
No, that's the government's position. That's Congress's position. You interpret this statute as allowing Mr. Pack to set up as many grantees as government entities as he wants and to appoint the board. That's the government's position. That's the government's understanding of the statute.
If Congress is, if it's consistent with Congress's appropriations, yes, that's any Congress. USAGM didn't form OTF out of thin air. It went to Congress and said, please appropriate this money so that we can form this entity as a U.S. international broadcaster.
The congressional
that makes it something more than just a grantee. There has to be something more than just grantee status to come under the statute, doesn't there? You seem to be claiming that any grantee is within the catch-all on this statute. Is that really the government's position?
No, not any grantee.
Being a grantee makes you authorized under the statute?
No, not any grantee, but a grantee that is agreeing or that is serving as a U.S. international broadcasting entity.
So what about, you said there weren't any, but actually in the reply brief of OTF at page 8, there's a reference to the revived Office of Internet Freedom and a press release, which has given money to private software companies to advance the internet freedom objectives of the office and also of USA Global Media. So I guess the question is, if they're authorized and they are agreeing, presumably in their contracts, receiving that money, then would the governance prerogatives of the CEO extend to them? And if not, what are you pointing to as a matter of the statute that would protect them?
Well, again, if they're agreeing to be subject to the dictates of the IBA, one of the provisions of the IBA is that USAGM CEO has authority to report.
Well, I realize your time's over and I'm extending it, and I hate to do that, but
it's all right.
Isn't it possible that there are two categories of recipients of money from the government under these programs, one of which is a grantee that may have pre-existed the grant, the type that Judge Pillar's talking about, or an entity which is created from its beginning by an authorized entity like Radio Free Asia, incubated, as the appellant puts it, within that agency and spun off with Congress's funding and permission. Isn't that different than just a grantee?
Your Honor, I agree with you that certainly this court could say that at a minimum, those characteristics that you're identifying.
Do you have to win on this proposition that all grantees could be covered? But
No, and we certainly don't agree that every grantee.
I'm wondering why you're even fighting that position at all.
Yeah, I mean, and I don't mean to fight it. I just want to be clear that,
Yeah.
certainly one OTF is in a unique spot because it was created, if nothing else, authorized under means an entity that was, formed as part of a different broadcasting entity that was spun off of that entity with congressional approval at the request of the agency, and so forth, qualifies as one authorized under the statute. Whether it extends beyond that, this court wouldn't have to reach that.
Is there a line item in the appropriations bill, in an act that mentions OTF?
Not OTF specifically. There's the there's the Internet Freedom provisions of the Appropriations Act that we cite.
Right, but there is no appropriation that line that specifically mentions this entity, is there?
Not that I'm aware of. No.
Right, it approves money for grants, but it doesn't approve it for this specific agency.
Well, I mean, for OTF or for I don't think it approves
for the Open Technology Fund, the entity.
I mean, to be honest, Your Honor, I can look into this, but I'm not aware that it actually appropriates money for Radio Free Asia either, or for.
Yes, that's fine, but Radio Free Asia is mentioned in the statute. You made an argument that sounded like Congress had authorized by making an express appropriation for this, and
yeah, I didn't. If I said that, I misspoke. The only point I was making there is that it made clear that the types of activities that OTF is engaged in, internet technologies, are funded by are part of international broadcasting. Congress recognized that those are activities that fit within U.S. international broadcasting.
Yeah, and that grants can be made.
Grants to further those interests. Yeah, at that point I was making.
This goes back to the question Judge Sentelle's asking. You are arguing that that any grantee who agrees to all these provisions can have their board replaced. This is not really a separate argument on your part.
Well, I guess I would put it two ways. I think that then we do agree that if you agree to the IBA and all its dictates, yes, but this court doesn't have to go that far to say that OTF is authorized under the act, because OTF, because of the unique circumstances surrounding OTF's creation and what it does and so forth. So although, yes, the government's position.
But none of those unique things that you're talking about, that's legislative history, right? That's not in any statute or appropriations bill.
That's correct, but
and nor is courts generally think about legislative history independent from statutory text.
Well, one thing I would point out, Your Honor, just the statutory text does provide that there will be consolidation of the other entities. So Congress clearly had in mind.
Yes, that's quite clear, and I think that would be quite right if it fell under that category, which are the consolidation of such entities. You would be fine, but that is not. You're not arguing that it falls within that category of the statute, are you?
No, but the point being is the reason why Congress created a general catch-all, and usually a basic principle of statutory construction is you look at the specifically preceding items. The reason it created is to capture what has happened in the past, which is things like consolidation or spin-offs of existing entities. At a minimum, it makes sense to interpret what Congress was doing in light of that history.
But the catch-alls normally use a word like "or otherwise."
Well, we cite a number.
The statute does not say "or otherwise authorized by."
Your Honor, we cite a number of cases in our brief where there was a general provision, any election in one case, any tangible item in another, in that kind of general phrasing that didn't include the otherwise authorized language. And Congress in the Supreme Court looked at these specific list of items to determine what that meant. And if you look at those items, the only thing that they universally have in common is also held in common with OTF, that they were fully funded by USAGM. They serve as a U.S. international broadcaster. They're providing a U.S. international broadcasting service. They're dedicated, and they've agreed to further USAGM policy and strategy.
Okay, we're over time, assuming no further questions. Mr. Beck, you have some time for rebuttal. Mr.
Thank
Beck.
you. I wanted to address Judge Sentelle's point about it being incubated, OTF being incubated in Radio Free Asia. And I think, the government makes a similar sort of connections between OTF, and it's sort of a guilt by association kind of argument, that because they sort of are associated with the same people and they're engaged in the same groups, that therefore they're authorized just like these other organizations are. And I think the problem with it is it's not consistent with the language of the statute. It says authorized under the act. It doesn't say, conceived of within an authorized organization. Only if an organization is authorized under the act. And the problem with that is OTF is not even mentioned in the act. It's not created. It's not given authorization to take any action or prohibited from doing any action.
In the very language, there are other authorized under this act, or authorized under this act, excuse me. Doesn't that suggest that we would not expect it to be mentioned by name in there? That's a catch-all, isn't it? That there has to be
No, Your Honor,
a possibility of an unnamed entity, or you don't need that language.
No, well, Your Honor, I think it could be authorized under the act either by being created by the CEO under section 6209A, which gives them the authority to incorporate new entities. That would be under the act. And also Congress could appropriate and authorize it in appropriations legislation.
Nonetheless, the fact that the act doesn't mention this entity by name doesn't really cut much ice when you have that language about or authorized under this act, does it?
I see what you're saying, Your Honor, but there are other ways that it can be authorized in appropriations legislation or the like. I see my time has expired.
Further questions from the bench? All right, thank you. This was a very interesting argument. We appreciate it, and we'll take the matter under submission.
Thank you.
Okay.
Case number 19-7117, Fadi Elsalameen, Appellant versus Bank of Palestine, P.L.C. Mr. Blakely for the appellant, Ms. Gately for the appellee.
Blakely.
Yes, sir. Good morning. My name is William Blakely. I'm here for the appellant, Fadi Elsalameen. I'd like to reserve 2 minutes, if I could, for my rebuttal. The district court order should be reversed for 2 reasons. Number one, Mr. Al-Salameen has satisfied the long-arm statute, and he's satisfied at least one, if not more, of the plus factors set forth in 423A3, the long-arm statute. There's been evidence of thousands of contacts in the District of Columbia. Tens of millions of dollars were exchanged by their customers, and there's been a persistent course of conduct with the International Finance Corporation. Now, the second basis for our position that the district court should be reversed is the position it took with the International Finance Corporation. The government contacts exception that was relied upon does not apply to the International Finance Corporation for 2 reasons. One, we have a non-resident alien, and it doesn't apply to a non-resident alien. And then number 2, the International Finance Corporation itself is not a government, a U.S. federal instrumentality. As a result, we believe that.
Mr. Blakely, I have a question about the long-arm statute. You're relying on 13423A4A, which requires tortious injury in the district caused by an act or omission outside the district, and it requires, as you refer to, the plus factors, regularly doing or soliciting business, or engaging in a persistent course of conduct, or driving substantial revenue from goods used or consumed or services rendered in the district. So those are the elements. But then looking at 13423B, says when jurisdiction over a person is based solely upon this section, only a claim for relief arising from acts enumerated in this section may be asserted against him. So does the claim for relief have to arise in part from those plus factor contacts?
Yes, thank you, Your Honor. The answer is no. Crane versus Carr, the leading case in the United States Court of Appeals for the District of Columbia, makes it really clear that no, there does not have to be that connection. And so the answer is no.
And I mean, that's sort of what I thought you were going to say, but it makes it really difficult to understand what role those plus factor elements are playing and how to understand them. If they're clearly not the kind of robust, persistent course of conduct that would be required to support general personal jurisdiction as a constitutional matter. And they're not, it sounds like, even the persistent course of conduct related to the claim that would be required for specific personal jurisdiction as a constitutional matter. And so I'm just trying to figure out, do you have a theory of what role they play? Because it's very general catch-all language. It's hard to know how, what kinds of conduct might be reasonably thought to meet those requirements.
Yes, thank you. I've looked at the conduct, of course, set forth in Crane versus Carr. And in our case, we have many contacts. They are, for example, as I mentioned earlier, we had the contacts by the shareholders. We had contacts by depositors. There were trips to the District of Columbia by very, very senior people. They were, in fact, the chairman and general manager of the bank, the chief international relations officer, the chief business development officer, and these took place over a number of years. And the International Finance Corporation contacts were also over a number of years. And former Justice Ginsburg, when she wrote the Crane versus Carr decision, set forth the factors of the defendant, and there were exchanges, with zoo animals, and there was a publication, and we went through all of those factors, and we have significant contact in the District of Columbia. But it's really clear in Crane versus Carr, they do not have to be directly related to the injury. So we have
So one way to understand it is that the plus factor is simply a decision by the legislature that even if, as a constitutional matter, there were a tort happening within the district caused by conduct outside, that if that person outside the district had never been in the district, never planned to be in the district, no relationship with, no benefit from the district, it just wouldn't really be fair. And there's a legislative judgment to have them have to appear in the district. And if that's the function that it's playing, then it would seem that a lesser level of continuous context might actually satisfy that policy interest. Here's a sophisticated defendant that is coming for all kinds of purposes to the district. And so the convenience, the legislative judgment, not the constitutional judgment about convenience, might be met. So under that theory, you might win your statutory argument. The difficulty I have is that it seems to fall so far short on constitutional grounds. So my question really is, how did this case get teed up this way? Why was there litigation or concessions or agreement or understanding about whether under Calder versus Jones, this defamation claim was constitutionally sufficient to bring defendant into the district?
I don't know. I wasn't in the case below, Your Honor, but I do believe you are correct that there does not have to be a connection between the injury in D.C., but there does have to be conduct in D.C., and that's what we have. We have years of conduct, not only persistently pursued by the bank for purposes of raising money. I think the judge below was confused with international relations versus investor relations, the quote IR contacts, if you will. No, these are investor relations that the bank was engaged in over a number of years, and it translates.
You're talking about, I mean, we don't have an exception, but one of the rationales for the government contacts exception seems to be if you're coming just to do government business, coming from another state because the United States is the seat of government, it seems like there could be an analogous doctrine that if you're coming from another country only because the World Bank, IFC, IMF are cited here, they could be cited in the Azores, but they're cited here, that maybe shouldn't count. And then I guess the counter argument that you make is, well, wait a minute, this is all commercial. But I think that's an open question, no?
Well, it is commercial. There's a 4.73% ownership by the International Finance Corporation of the entire bank. And that's significant in addition to the shareholders that they had other shareholders, they had also deposits. And it was, the way I look at it, Judge, is this. The plus factors, they don't provide jurisdiction. We have jurisdiction on the long-arm statute because we have two things. One, we have a out of DC, just happens in this case, it was an alien, or hurting a DC resident. And then the plus factors are added in as a way of filtering out those cases where the contacts are not that significant. So in this case, what the judge did, she did what we refer to as, well, she should have taken an aggregate approach to this whole analysis. She didn't. The judge looked at, understandably, but she'd look at the website, or the judge looked at other shareholders. And then they would discount that contact and then say, well, there isn't enough here, there isn't enough there, website isn't enough. But collectively and in the aggregate, there were substantial contacts.
So what about I know you weren't counsel then, but you have the responsibility now to defend this appeal as it comes to us on the record. You say now that we should exclude the so-called government contacts, but when the district judge ruled that discovery would be limited and not, well, initially the district court allowed discovery. Then when the government said, no, we will not afford discovery into government contacts, the Al-Salameen did never ask to move to compel, did he? He didn't move to compel and say, well, no, you should provide that information because it's relevant and it's within the scope of the discovery.
I refer to this as the shield and sword argument, because the truth is here, we have an individual DC resident who is hurt, and the bank took a cover behind, if you will, the judge's order. And the judge's order was really clear. As a matter of law, we are not going to consider any of these contacts by this foreign alien in the District of Columbia, period. So the answer, though, to your point is, yes, there was not a motion to compel, a motion to reconsideration. What there also was a motion for a protective order by the bank. I mean, this is, the judge ruled, and it's almost like there's somehow a mandatory interlocutory appeal requirement. I don't believe there is, Judge. With all due respect to my opposing counsel, I don't believe there was a requirement to do that. And as we know, it's expensive, and the judge was really clear on how she was ruling. So we only have a couple of minutes left, so I wanted to point out we did
Actually,
it.
you don't have any minutes left.
I'm over. Okay, thank you, Your Honor.
Yeah. Does
Then
anybody?
I'll save my comment for rebuttal.
Okay, fine. Thank you.
Thank you.
All right, we'll hear from Ms. Gately.
Hi, good morning, Your Honor, and may it please the court. My name is Mary Gately, and I represent the appellee, the Bank of Palestine. Your Honor, I want to cover three principal points with the court today, and really the district court's dismissal of this case for lack of personal jurisdiction should be affirmed. First, the contacts found by the district court after granting extensive jurisdictional discovery on the topics requested by the appellant did not satisfy the long-arm statute, which was section 13423A4, not A3, as the appellee's counsel suggested. Second, Mr. Al-Salameen forfeited the arguments raised related to the government contacts exception that he raised for the first time in this appeal. Third, the government contacts exception applies on the facts of this case.
Well, the government, I mean, the district judge was very clear about saying you can do discovery, but nothing about governmental or intergovernmental entities, World Bank. So he does have a point. We're supposed to butt heads further with the district judge, or is that, it seems like that would ordinarily be enough to preserve it, the combination of that ruling and a broader request on Al-Salameen's part.
Yes, Your Honor. I think that if you look carefully at the facts, Mr. Al-Salameen cross-moved for limited jurisdictional discovery. He never submitted the actual interrogatories or document requests that he requested. He submitted topics. The bank opposed the motion, the cross motion for jurisdictional discovery. And importantly, Mr. Al-Salameen and his counsel never filed a reply brief to that cross motion. I mean, to the opposition that the bank filed. And the bank raised the government contact exception in that opposition. That's at JA 112. And you can see also at JA 91 is where that cross motion and the general topics that were raised.
Excuse me, what's the date of that motion? Sorry.
The date of the cross motion?
Of your response there. What was the date you just said?
Oh, yes, Your Honor.
112.
We filed, so the district judge ordered that the bank consolidate its reply memorandum in support of the motion to dismiss at the same time as it opposed the cross motion because
What's the date? What's the date?
August 30th, 2018, JA 95.
Do you have a sense? You were involved in the litigation before, Ms. Gabriel?
Yes, sir.
And do you have a sense of how it was that the statutory issue? I mean, it makes sense that the statutory issue would be decided before the constitutional issue, but it just strikes me that there really is a question whether there's a claim here, a defamation claim that would constitutionally be raised in the DC forum given Calder versus Jones, and that was never, has that been conceded? I feel like I've read something.
No, Your Honor.
It was conceded.
No, it was not conceded, Your Honor. If you look at the lower court briefs, the due process issue was briefed. And I should point out that when the plaintiff brought this case, Mr. Al-Salameen, he never specified any provision of the long-arm statute. We moved to dismiss the case, saying there was no general or specific jurisdiction under any of the sections of it, and no due process. And so that's briefed in our initial motion to dismiss at JA 36 through 37. Mr. Al-Salameen addressed the due process in his brief, and then the bank addressed it again in reply at JA 107 through 109. And it's our position that this case would not, even under all the facts and circumstances that Mr. Al-Salameen has put forward, satisfy due process, constitutional due process.
So here's my question for you. Assuming a claim, a defamation claim that satisfies Calder versus Jones and Keaton versus Hustler and as a constitutional matter, and obviously satisfies the long-arm statute, the subpart A that requires tortious conduct outside the forum that's causing harm within, then the only battleground is the plus factor. And wouldn't it make sense to read, in that case, to read the plus factor the way I was suggesting as a relatively minimal check so that, the 18-year-old blogger in New Caledonia isn't hailed into court in DC, but the Bank of Palestine is.
Your Honor, I don't think that that's how it's been interpreted. I think those plus factors are, I think there are substantial due process concerns when the contacts with the forum don't relate to the claims. And
that's why I posit the situation in which the contacts are, I mean, the defamation or the tortious conduct itself, because it's targeted at the forum and assuming, and I'm not saying that that's this case and it hasn't been briefed, but if it were the case that the brunt of the harm, the situs of the harm is the forum. So you have, Shirley Jones, just like in Collar versus Jones, in DC. And my question is, what does the DC, the legislation mean in having those plus factors if that might be the out of jurisdiction, out of forum tort that's causing effect in the forum? And I'm thinking it's as I said, sort of a reciprocity. You're coming and you're benefiting from the law here, and so we're going to hail you into court here. But if you're really off, the teenager in New Caledonia, then even though constitutionally under Calder versus Jones, we can hail you into court here, we, the District of Columbia, don't want to go there.
Yeah, Your Honor, I think. Based on the facts, it's not that kind of hypothetical that you've posited.
No, I understand that's your position. I'm trying to get your help me in understanding how we should see these plus factors and what their function is.
I think you have to. There's precedent in this court, repeated precedent in this court in the 4S v. Ralph case, where you have to first look at the statutory factors, and then you turn to due process if you find that the statutory factors are met. And so I would submit to the court that the statutory factors haven't been met in this case, and there's a perception that that has been suggested by the appellant that the district judge didn't carefully consider these factors, as has been done by many other courts in this jurisdiction. And I think that's really it's not a fair reading of what the district judge did. The statute itself is set up with these three requirements. And when you look at the words, regular, modifies, does, or solicits business, engages in any other persistent course of conduct, substantial is modifying, deriving the revenue. So the court had to look, at the various factors, as has every, court that I've read in reading a lot of these cases. If you look at the Berman v. Worldwide Industries case, the judge does the exact same things. You have to look at these kinds of categories and consider whether or not they even apply. And that's what this district judge did. She did it carefully. I would also note, if you look at, for example, Mr. Al-Salameen's supplemental brief at the Joint Appendix 889 through 894, Mr. Al-Salameen grouped these contacts in the exact same way that the judge analyzed it. And I would submit that she looked at the quality and nature of the contacts in each of these. So the fact that you have 4 customers out of almost 1 million customers is not a significant contact with the District of Columbia. There's no evidence that those corporate the customers were acting or that the bank was acting in the District of Columbia through having those 4 customers incidentally located in the District of Columbia. In fact, what the evidence shows is that those interactions were occurring in Palestine. That's why NGOs or something like that would even have an account with the Bank of Palestine, because they have operations in Palestine. So I don't think any of the facts that they've submitted under the existing law of this circuit, for example, 30 emails written over a period of 4 years to a global email list that did not target the District of Columbia, did not solicit business, sent to a small group of people in the District of Columbia, which the bank credited as informational, not solicitations. The transactions that are referred to, there was only one transaction that occurred via the website for a total of $578. And importantly, the amount of revenue from those 4 customers over the 4 years that the judge gave jurisdictional discovery was a mere $6,685, which pales in comparison to the net commission and interest revenue of the bank, which is over $100 million. So there's no basis on which you can accumulate these factors to say that there was that the modifiers in the statute are satisfied, the persistent, the substantial, or the regular. Those things just do not apply. In the limited amount of time, I'd like to cover the government contacts exception. If the court will indulge me. First of all, I covered the forfeiture point. Our position is that they forfeited that. On the government contacts exception, there's more than one purpose behind the government contacts exception. You have, in the environmental research case, not only a First Amendment right to petition, but whatever we want to call it, a recognition of an interest that the District of Columbia does not want to turn into a national judicial forum. I think that could be a policy. You can reflect on it as a policy decision by the DC legislature that the federal courts sitting in the District of Columbia are bound to accept. There's also the due process underpinnings that are at issue here that you've spoken about, Judge Pillard. If you look at the cases that the appellee relies upon, the Rose v. Silver case, as well as the Lex Tech Skillman, they both carve out that in cases in which the due process interest is exactly at issue, when you have the contacts that don't relate to the claims in this context, which is what we have here, in particular, that's when you have the sensitive need for the government contact exception. So there is a due process underpinning.
Ms. Gately, as you say, A, the constitutional claim has not been adjudicated by the district court, and B, if you assume, as we can in the context of defamation, that an out-of-forum tort with in-forum effects can, at least the Supreme Court has recognized that that alone, without further context, can satisfy due process.
I don't understand. Can I ask here? I'm not clear about this. So in Crane, the court held that the DC did not intentionally go all the way up to the limits of due process. So that isn't it the case that even if the defamation claim alone would have been enough, that's not the question before us. It still has to reach the plus factors. And in Crane, the court also says that those require, because of the use of persistent and regular, et cetera, that there be a continuing set of contacts, right? And that's all there is to it. The DC Court of Appeals has already explained to us, Ms. Gately, what the meaning of that section is. Am I wrong about that?
Yes, I would agree with you, Judge.
Now, I'd like to ask a question about the forfeiture issue, and I want to understand the timeline for a minute. So the district court permitted Al-Salameen to conduct discovery excluding the contacts with the government. That was in November of 2018. Is that right? That's the JA6. That's the court's permission to conduct discovery.
Yes.
All right. Then in 2019, the bank objected to the extent that the discovery request sought information on the bank's interactions. That's JA 176. And at that point, Al-Salameen doesn't move to compel or otherwise to object. But in February of 2019, he files a supplemental brief opposing the motion to dismiss. And he doesn't discuss the government contracts exception at all.
No, that's correct.
That's JA 893. Well, wouldn't that be the place to raise the issue? Just not a motion to reconsider or anything like that. That's a opposition to the motion to dismiss.
That's correct, Your Honor. The district court allowed the parties, after jurisdictional discovery was completed, to file supplemental briefs. And there was no contesting the government contacts application at all by Mr. Al-Salameen in any form to the district judge. You simply don't find the arguments that are now being raised on appeal ever raised to the district court. And therefore, she couldn't pass on those things. And this is exactly the kind of case that should have those arguments.
What was never raised? The
non-resident alien application, the two commercial, if you will, that there's, the government contacts can't be applied in what they characterize as a commercial way, although that's not even accurate under the case law, Your Honor. Commercial, if you're relating to the core mission of the government agency, which in the case of the IFC, the mission is to partner with private sector to assist with development in developing in poor countries. So coming to the District of Columbia to interact with a government agency like OPIC or the World Bank and the IFC are really the only place you can come to do that is the District of Columbia, and those contacts don't count against you, whether or not they're characterized in the way that has been done by the appellee in this case. I see that I'm well over time.
You are. Let me just ask whether anybody else on the bench has any questions for you.
No further questions.
Okay, thank you very much.
Thank you, Your Honor.
Does Mr. Blakely have any time left?
Counsel was out of time.
I'm sorry?
Counsel was out of time.
All right, we'll give you 2 more minutes since we went over the proposal.
Thank you, Your Honor. I'll be brief, although that I know is somewhat of a misnomer sometimes with lawyers. The harm occurred here in the District of Columbia to a DC resident. I think that's really important. I think Mrs. Gately's trying to set a new standard.
I don't understand why that's relevant. The statute assumes that the harm occurs to a DC resident, and the issue is, do you meet the plus factors?
I would agree. Yes, Your Honor, that is exactly right. I mentioned that because that's not really an issue before the court. So we are just going through these plus factors, and what it appears to me is that they're trying to layer in another requirement. The plus factors, according to Crane versus Carr, which is the leading case, are to be evaluated, but they're not jurisdictional requirements. Jurisdiction is
Well, you don't have, excuse me, you don't have jurisdiction if you don't have a means of achieving personal service. That's the purpose of the long arm statute. So if you don't meet the long arm statute, there's no jurisdiction. That's really all there is to this here. So I don't know how you can say they're not jurisdictional. They are jurisdictional. They may not be constitutionally required, but they're necessary for personal jurisdiction. Isn't that right?
I think that is right, but the plus factors are not jurisdictional. Those are a filter.
Excuse me, they are a filter without, if you do not succeed in getting, you don't get jurisdiction because you can't get service. Isn't that right?
Yeah, but service of process, if you're referring to service of process?
I'm talking about personal jurisdiction. You can't achieve personal jurisdiction without achieving service of process, and you can't achieve service of process unless you satisfy the long arm statute, right?
Well, in this case, I think that's right. Yes, Your Honor.
Okay,
and in this case,
one other question about the timeline question I was asking. At any point in the district court, before the district court issues its 2018, its 2018 effort orders with respect to discovery, is there any point where Elsalameen argues, any point, that the government contacts exception does not apply?
he certainly, in terms of his assertions in the complaint, they are replete with arguments or allegations.
I understand. As a matter of law, is there any point where you make the legal argument that any legal argument that the contacts for any reason don't should be that the government contacts exception should not apply here?
I wasn't. Yeah, I'm
Go
sorry.
ahead.
Yeah, no, I don't know the answer to that, Your Honor. I don't believe so, but I know that the judge's order was really clear and it limited discovery. And what we never had was a motion for a protective order by the bank to say that, hey, we're not going to produce these contacts. Following the order, the discovery, which I don't have the site to, but the discovery requests that went out, they went out after the judge's order. There should have been a motion for a protective order.
Well, I don't know. I mean, I'm sympathetic to your point that it's what Al-Salameen asks for. But then when the bank, in the cross motions for jurisdictional discovery, the bank argues that its contacts with IFC should be excluded, there's no reply brief there, which would be the perfect time to raise it. I mean, it might have even persuaded the district judge. And that's why we have these preservation requirements. So we're not sandbagging a trial judge who never was presented with the question, with any briefing on it. So we don't have any reply brief there. And when the bank raises it in objection to an interrogatory, then Al-Salameen doesn't move to compel the response to that interrogatory. For example, saying even if there's a government contacts exception, it doesn't apply to the IFC because that's commercial or something like that. No such motion to compel. And then in the post-discovery supplemental briefs, nothing about, well, of course, we disagree with this, but we're preserving that. I mean, you don't have to butt heads with the district judge. But I think the question is, was the district judge ever fairly presented with a dispute over the legal applicability of this exception?
Well, we believe that the judge was, but I think our position is pretty clear also that irrespective of the IFC, there were sufficient contacts in the District of Columbia to support jurisdiction, irrespective of the IFC. Yes. Thank you very much for your time.
Thank you.
Oh, yes, you have, oh, I'm sorry.
No, I just wanted to see whether any other judges had any questions. Apparently not. We'll take the matter under submission. Again, thank you for a very interesting argument this morning. Take care.
Thank you, Your Honor.
This honorable court is now adjourned until Monday, October 5th at 9:30 a.m.